Thanks for coming. I'm Jeff Northrop. I'm the Chief Technology Officer at the International Association of Privacy Professionals. We are a nonprofit, non-advocacy organization supporting those who deal with the troubles and woes of information and privacy. I know I've got limited time today. My watch is broken, so I'm going to be checking my cell phone. Please give me time for 2 minutes.
I'll give you when there's 10 and 5 left.
All right, I may check this. I'm not checking messages, I swear. So I'm really happy to be here today. I'm glad to see people showed up. I know this is generally a technical crowd, and this is sort of a policy kind of issue. But I think it's an important issue for the information security community to better understand, because we're seeing more and more, and I see it among our members, which, if you go back by history, we're legal people and then compliance people. Now we're starting to see more information security professionals in and among our members, because you're being asked to deal with privacy issues. And securing the data and getting the okay from your compliance team is not necessarily 100% coverage on issues of privacy. So what I'm going to do today is I'm going to talk a little bit about the history of privacy, very little, and how we got to where we are today, and why there's such an explosion of regulations and so much interest in it. And then I'm going to walk back through what a privacy program looks like at an organization, how components of it are constructed. So let's kick this off with a brief history lesson. When we go back to 1890, we have Louis Brandeis, who is not yet appointed Justice of the U.S. Supreme Court, but is becoming noted for his work to support the common man. Authors an article, or an essay, in the Harvard Law Review that talks about the risk of a loss of privacy to its citizens from the technology of the day, the new technology of the day. He called it the right to privacy. Anybody want to take a stab at what that technology was? Telephone? It's a camera, right? And what he does in this article, and you can still go back and read the article, it's fascinating. He cites this case where a group of people were meeting in private. They didn't want to be seen, recognized, meeting together, and there was a photograph captured of it. Right? And so this was their loss to privacy. And Dan Greer talked about it this morning, the unobservability. I changed the slide because I love that word. Right? So the fact that they were to be able to be observed, and it was one of the first times in history where it wasn't one person's word against another that something happened. You were capturing them in the physical sense. And this was not a concern that expanded out to the common man. I mean, this was a concern that was among the intellectual elite, academics, judicial people, lawyers, and we see it over and over again throughout history. And we see it with the advent of movies, we see it with the advent of television, we see it with the advent of radio, that people are concerned that there's a loss of privacy because they're being observed in a sort of physical way, in ways and captured in ways that they couldn't have been subjected to before. And in 1967, Alan Weston, who is largely considered the grandfather of sort of modern privacy thought, writes in the seminal textbook called Privacy and Freedom, which is still in print today, about the risk of a loss of privacy from, again, the new technology of the day. This is computers. The fact that we were able to gather bits of data about people and corroborate them and correlate them in a way that we hadn't before would be a severe loss of privacy to the individual citizen. And that's sort of the way we think about it today. We do still think about being photographed as a loss of privacy, but I think in the larger context, most of us would think about it in the sense that data. The data we have about us can be correlated to expose secrets or things that we want to be kept private. And Alan Weston was very influential. It wasn't long after that textbook, and others that followed, and his public speaking and his role as a professor, that he helped push forward the Privacy Act of 1974. Now, if any of you work for the government in some capacity, you're still obliged to follow this. This is the laws that limit what governments can do with the personal, the U.S. government, I should say, what they do with the personal information they collect. That's still in force. And if you think back to 1974, and people's concern for privacy was fear of what the government could do. And we see this throughout. We have the OECD coming out with their very tersely named Protection of Privacy Trans-Border Flows of Personal Data. I had to take a breath in between. that laid out a framework for how personal data should be protected and stored for the very same reasons that Alan West had outlaid in 1967. That's followed in the mid-90s by the EU Data Directive, the European Union. Do we know what the Data Directive is? So the EU Data Directive is an incredibly robust set of, I don't want to call it a regulation, it's suggested regulations that were drafted in the European Union that would help their citizens be protected from a loss of privacy. And what it does is it gives incredible control to the citizens of the EU over what companies or public or other private entities do with the data they collect. So if you hear the privacy laws are tough in Europe, it's because of the Data Directive. And this was a seminal moment. I mean, this is 1995 they drafted it. In 1998 it was released. I mean, if you think about where the World Wide Web was at that point, it was in its infancy. And I don't want to get too deep into laws and regulations here because I don't think that's necessarily appropriate. But understand that directive, when it was set out, is still sort of the high mark for what a government can do to protect its citizens from a loss of privacy. The U.S. is not near that at all. And actually, if you want to look up something interesting, you can go. Forrester produces a heat map of privacy laws, and the hotter it gets, the more robust those laws are. If you look around the world, Europe is red hot, and Hong Kong and Singapore and Argentina are red hot. The U.S. is not quite ice cold as China, but really cold, right there with Russia with our laws. So our laws aren't robust at all. But we do have an awful lot of laws here, and they're sectoral based. Right? So we have, right around the time the EU Data Directive came out, we decided to protect our citizens not just from the government, but also from health. We had HIPAA, followed by the bad actors around 2000, remember Enron and WorldCom and Adelphia and on and on and on, and proliferation of data breaches and loss of credit cards. We get SOX and Graham-Leach-Bliley, and then FERPA to protect students. We got COPPA protecting children. We got the Fair Credit Reporting Act, which actually creates some of that, and on and on and on. And we have this menagerie of laws and regulations. Not to mention it, and Dan Greer this morning, Dr. Greer talked about the California data breach notification law. That is one of 46 different laws across this land. I believe he hinted that there were some differences among different states. There are a lot of differences among the states. There are 46 laws among 48 states. All protect their citizens' privacy in a different way. It's a mess. And the regulations are prolific. They're very recent. If you look at the history from Louis Brandeis back in 1890 to 1967, and then from 1967 to the mid-90s, which is the EU Data Directive, to today, it's been a veritable explosion, and it's not slowing down. Dr. Greer also mentioned there are 25 bills throughout the Congress right now talking about cybersecurity. Almost every single one of those has some privacy component to it as well. So they're coming.
If I could interrupt you with a quick question,
yeah.
Feel free to take it offline. Can you comment on the level of compliance burden for the EU Data Directive, which provides more robust privacy protection for citizens versus the U.S. patchwork approach to laws. Do you have an idea of what the compliance burden is relative to those two?
Can you repeat the question, please, for the recording?
Sure. So you want to talk about how difficult it is to comply with the EU regulations
level of
versus,
effort. Yeah.
They're worlds apart. So there's two things with the EU data directive. One is it's a framework. It's actually not a regulation. So when it was released in 1998, and I'm not going to spend too long on it, we can certainly talk about it offline. When it was released in 1998, they intended the European member states to adopt it sort of whole cloth and maybe tweak it a little bit. It was haphazardly adopted. It's like a Swiss cheese. So Germany is really robust, and Italy is kind of robust, and France is not so great, and the UK has got its own set of laws. They're very difficult to comply with if you're operating within those countries. If you're just doing transport of data flows, we have safe harbor laws here. And if you're safe harbor compliant, then generally you're okay. The laws here in the US are, we're a libertarian kind of society. So if there's no harm done, we're not going to create a law around it. Well, they're using health data, HIPAA. Oh, they've lost credit card data. We need PCI. And on and on and on. The compliance is tough, and I'll talk about how laws and regulations roll into a program, so you can work with those. And that sort of leads into my next slide. Is that we're security professionals. We know how to secure the data, and securing the data is really important. Any compliance people in here? So a couple of compliance people. We have compliance is a growing function within an organization. Laws and regulations are complicated. We need compliance professionals to help us manage those. Compliance is great too. The two definitely need to work together, right? Compliance people. But it's still not. That still doesn't cover the entirety of privacy. And we have two very recent examples that are that highlight why that's the case. One is PAC, the mobile app. It's a social platform for mobile applications. When they said in their privacy policy that, hey, when you install our application, we're gonna mine your address book that's on your phone and upload it as part of our installation. It's sort of obtuse language within a privacy policy, and they said it. Click their yes, I agree, okay, whatever it was, and it did this. When it came out in the public that this is actually happening, I don't know if somebody read the privacy policy or reverse engineered the app or whatever they did, it blew up. It exploded on them. And the FTC came down on them. And very recently, they agreed to a settlement. I don't think they actually admitted guilt, but they agreed to a settlement where they're under a 20-year consent decree that requires them to subject themselves to a privacy audit every year and submit the results to the federal government to ensure that they're compliant. Right? But they didn't overtly break any laws. And the same thing happened with Google. It's happened with Google a number of times. The most recent one is the Street View debacle, is how we call it. Right? So they were driving around with their camera on their car, mapping things, and one of their engineers decided, we could use, this would be kind of cool. Let's, just out of pure interest, not really business interest, just curiosity, let's collect the Wi-Fi traffic from unsecure routers on public streets and not trespassing, and they did. And I don't know if they ever got to the point where they found any interest in it, but when the FTC got wind of what they were doing, it came down on them again. They paid a $7 million, they recently settled, and again, no admission of guilt, they settled for a $7 million fine. They're required to spend some odd millions of dollars on public education for securing their Wi-Fi routers. So look for those newspaper articles and whatever else they're going to get that out for securing Wi-Fi routers. And again, the same sort of consent decree with privacy audits, which they were already under for what they do with Buzz and subverting Safari's third-party cookie preferences. And these are interesting cases because you can have robust security, you can have perfect security in that case. You can be really robust with your compliance and still fall prey to what the FTC is enforcing under. And they're getting more bold about enforcing on this reasonable expectation of privacy of their citizens. Right? So Path and Google both violated a reasonable expectation of privacy, even though they didn't violate any law overtly. So that's sort of a cautionary tale. And it leads to why all of a sudden is all this stuff about privacy? Why is the FTC going more aggressively against companies over privacy? Why is it in the major media every single day? Every single day you can find some news in a major media outlet talking about something about privacy, where even 5, certainly 10 years ago you saw almost nothing about it. Well, there's two things going on. There's two sort of actors in the marketplace that are growing, and as they grow and they battle each other, it's creating an incredible tension. One of those are the general consumers, and I've written part of the statement up here, but consumers currently feel a loss of control of their personal information. That's a very carefully constructed statement, and I want to give credit to Dana Boyd, a very talented and interesting Microsoft researcher. If you ever get a chance to read her stuff or see her speak, do so. And I like that statement for one specific reason. Because when we talk about, generally, when we talk about people fearing a loss of privacy, it often concludes with, well, we just share too much. And I think that's kind of bunk. I mean, we share information all the time, and you guys know this, right? It's not just social media where we share stuff. We know we're sharing information when we're surfing on the web, unless you're using a Tor or other proxy or some extraordinary method that no average user would ever be able to implement. We know we're sharing personal information on search engines and other things online. Certainly we're sharing information on our smartphones. I think everybody gets that. We share our personal information with the dumb phones too, right? Location data, call history. Everybody get an E-ZPass in your car, and you're sharing your personal information at E-ZPass. And with your credit card and Shoppers Rewards cards, most definitely. That's why they give those things to you. We share our personal information when we talk to our doctors. So we're sharing prolifically. And all of those services are becoming part of our daily lives. I mean, people aren't shying away from them. They're embracing them, and they're growing, they're exploding. So it's not, to say that we all have a fear that we're oversharing just doesn't pan out. I mean, people wouldn't be using these things if that was their fear. So when I say they're fearing a loss of control of their personal information, it's not that primary actor that they're sharing with. It's the secondary uses and the tertiary uses of that data. So you're okay when you post stuff on a social media platform, but who else has access to it? And where is it being stored? And what purposes are they using it for? And do I have control over that data? Sorry, I'm banging on the mic. And why is it so difficult to answer those questions? You have a question. Well, do you have answers to those questions?
I don't have an answer to the question because I think there's a mixed bag here. I think people are not paying attention to what's going on around them. If you're in Facebook and you want to play with any of those apps that come your way, whether it be the yearbook or other sharing, like this, whatever, a lot of those applications, they have an agreement right up front that says you're agreeing to share everything, not just a piece of what your information. They're saying you're giving this application access to all your data in Facebook.
Absolutely.
And yet people just
Absolutely.
grab them all the time.
And that's my point. They're happy to do that.
Right, so
Facebook's a great example because you have incredible control over how Facebook uses your data within a certain limit. But really, they've gone to extraordinary lengths to give you pretty good control over what you're doing. Yet people's, 1 billion people now, right, or somewhere close to that, are using Facebook. So that's what I mean. They don't fear that. But when you talk about, well, you're being profiled for advertising purposes, that gives people the heebie-jeebies. That's what creeps them out. And that's why, and it's why I describe it as a fear of a loss of control of the personal information. When you share something on Facebook, if Facebook was the only one to have it and you were able to remove it back, I think people would be okay with that. It's the propagation.
Those agreements go, but those agreements say that they have the right to use your information for virtually any purpose, including sharing it out with other partners.
I agree with you, and that that's sort of required by law to be transparent. But let's show of hands. How many people here read privacy policies?
I think this is probably not.
So we have about 5 people raise their hand. There's probably about 20, 25 people in here. So even among this community, that's small. And I'll speak to communities of privacy professionals, and I'll have even less people, right? You get the statement, even worse, you get the statement annually from your credit card company and your bank. Did anybody read those? Anybody have a question?
Actually, yes and yes. You made a very, very important statement. People want to have the ability to pull the information back, and a key to being safe harbor compliant, a key to people's comfort level with privacy policies is there are statements within these privacy policies wherein I can pull the information out if I want to. The moment it starts getting into third parties, they lose the ability to do exactly that because they're not the ones who gave it to the third parties. The relationship between this company X and this company Y and this company Z gave it to those third parties. And so a key challenge to implementing privacy successfully in your own privacy policy is being able to track what you've shared with your partners so that if your customer comes back and says, pull my information back, you have the ability of pulling it back from every place you've shared it with.
So this is one of those areas where I work for a non-advocacy organization, so we can't promote certain best practices. That is certainly one train of thought. And you see that with the EU data directive. Dan Greer talked about the right to be forgotten. And that's exactly what the right to be forgotten is trying to enforce. Is you track the original collector of the data owner tracks the data through all its uses so you can pull it all back. Another train of thought, and this is largely the way the US laws, unless you've got health information, financial information, or really the government, are architected, just require you to educate the user on what they're doing when they're submitting their information to you, right? That's notice. You have to provide adequate notice, and that's why you see the proliferation of privacy policies. Which one is the right one, is really an open question.
I was signing up for some online service or website, and it must have been 100, 110 pages long, and I'm like, I don't have time to read this, so I click through it. And I know that bills in Congress are kind of the same thing too.
So this is, and so I will get to the final of the slide that talks about that tension, because these really hit on it. But with regard to that, that's where the FTC is going after reasonable expectation of privacy. So if you've got something this size, and you put something 64 pages on it, it's not reasonable to expect the consumer to have read it.
But just going back, about reading the privacy. This is the whole opt-in, opt-out. I think a lot of people who were signing up for Facebook didn't know they were opting in to sharing so much information. And I think I'm not sure if they changed the original way that they were doing it, but I think that when you even signed up, you were opting in for a lot of things that you weren't aware of.
Yeah, so there are, and there's no way I'm going to get through my entire slide deck at this point. This conversation is great, and I'll make sure I have the slide deck available for you guys. But in the program itself are accommodations for that, and it specifically talks to. So everybody knows what NIST is, right? Yeah. The 800-53 publication is their security controls. They just updated that with a new revision. It is no longer, I think it was information security controls for federal agencies, blah, 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 blah. It is now information security and privacy controls. And they added an entire appendix of just privacy controls that really outline what a privacy program should look like. And and I'll just make the point now, I was going to make it later, but I think it's important to recognize the significance of that they're specifically calling out the information security community to handle privacy issues for the US federal government. Now, a lot of other people voluntarily adopt those NIST standards, but it's one of those things to watch, whether that's a bellwether, and I don't know if SANS or CERT will start including privacy controls. AICPA certainly has something in it. It's one of the reasons why I'm here, is that you guys are being, I think I said it at the beginning, you guys are being called upon to handle privacy issues more and more. So let me finish this tension. So we've got consumers fearing loss of control of their personal data. On the other hand, we have the ever-present march of technology. And again, Dr. Greer talked about this morning how it was just easier to keep all the data you had. It was cheaper than to try to analyze it. We have massive amounts of data, and Moore's Law has given us the ability to collect and store and process unlimited amounts of data very inexpensively. And there are businesses built around this. This is the big data thing. Right? I hate the term big data, so I'm just going to say data analytics. But data analytics, where not that long ago was really a slick competitive advantage. If you were doing sophisticated data analytics in the early 2000s, you were cutting edge. Right? It is now sort of a cost of doing business. Everybody's doing some form of data analytics. I mean, Walmart's certainly doing it to control their inventory, but the WHO is using data analytics to find flu epidemics, and the UN is using it for political outbreaks, find out where the political hotspots are likely to be. And it's improving our quality of life in many ways, and it's driving business innovation, and it's bolstering our economy. And data analytics is sort of the next evolution of our technology growth. And if you think of that as an engine, right? The engine driving all of these things, what's the fuel? Well, it's personal information in a very significant way. And so if you think this is bolstering our economy, it's driving innovation, and it's improving our quality of life, everybody loves it. But you marry that with the fear of loss of control of personal information, and you're really set up for a great deal of tension. And that's what we're seeing in the marketplace. And if there's one thing I want everybody to take away from here, it's that. Because that's causing all the regulations. I mean, the regulators, as cynical as we are about our politicians, they do try to resolve it. But it is incredibly difficult to, at once, reduce people's fear without stifling business innovation. And this is where you get the tension. You have the EU regulations that really try to reduce fear. And people have a lot of trouble doing business and innovating in that environment. We have the US where, well, if you tell them what you're doing with the data, you can do anything you want with it, and it drives innovation. Nobody's found the correct solution for that. So where does that mean we're going? Well, there's two things we need to do to get privacy right. One is accountability. And the information security community, compliance folks, we get accountability, right? We have programs in place, we do reporting, we have metrics, we do all of these things to ensure that we're protecting our data and we're managing our risk, and that makes, and we're okay with the accountability for having lost that. We're comfortable with that. Transparency is something information security doesn't do very well. Notifying the consumer why you're collecting the data, how long you're going to store it for, how you're protecting it, what kind of controls they have over them. That's where privacy is going. And whether it's the EU model or it's the US model or the model that's in Asia, and Asia has some very robust laws that are very different than both of those, it's largely looking to educating the consumer on what you're doing with their data and being accountable if you lose it or misuse it. And so the rest of this slide, I'm going to skip over it, but I'll mention one thing. It talks about how privacy is sort of proliferating out. I'm already down to 10 minutes. I have failed you guys in sticking to my slide deck. So, I was just talking about how important it is. I'll mention this one thing. This is a case in point of where privacy is going within an organization. David Hoffman, very well-known, respected privacy guy, was CPO of Intel forever, 10 plus years, came from a legal background. He's stepping aside to focus on policy for Intel, still there. In his place, instead of you know, the next in line for legal, they promoted Malcolm Harkin, who is their information security guy. He's their CISO. And they retitled him from Chief Information Security Officer to Chief Information Security and Privacy Officer. And they gave him the privacy program to run. Clearly a technical guy, no legal background whatsoever. And I'll leave that for you guys just to stick away in the back of your head. So let's talk about what a privacy program looks like. And this is sort of administrative stuff. You need somebody to head it. Oh, go ahead.
Yeah, just real quick. Having an internal privacy program, isn't that like the fox running the henhouse?
No.
Why would you not want an outsider, third party, to come in and say, instead of you doing all this yourself, as the retainer of data?
Can you repeat the question?
So yeah, would it be better off using an external organization to manage your privacy? Because I'm not sure why you would do that other than...
Well, if you're the one using the data, why would you have strong privacy structures?
Well, I mean, that's sort of a cynical look at it. You know, that's like saying, would you only secure the data to the minimum legal requirement?
Right, because it
that's
costs
not
you
enough.
more.
There's brand problems. There's PR problems. There is certain risks, and I think a team that, and I don't know whether it's better to have it internal or external. I think that's up to the company. But having somebody that understands your processes, that knows the players, that understands the business units, is probably better set to talk to your board of directors or the CEO, CFO, COO, and get support. Would be my thought.
It's basic risk management, and you want to manage risks internally, and that's why they're turning to a chief security officer to become a chief security and privacy officer, because what a chief security officer is very comfortable with is managing risk. What you want to do is very much like what you're doing with the security program, where you have external audits through a SOC 2 program or through an ISO 27000X program.
I want to make sure
external audits on the privacy side are essential.
I think everybody understands. That's a great point, and I think we all understand that. I believe. So I'm gonna. Right, this is my auctioneer move now. but have somebody to head a team. Get a team that's across. You know, somebody that you need. I have a chief privacy officer. It doesn't matter what the title is, but they have to have authority across business levels and be accountable to the board. And then gather a team from different business units and constituents within the organization so that you're properly managing the program. You're not just making decisions that may affect other areas, and setting a vision. And I'm going to skip the vision. Okay. Anybody speed reader? I'm sure. Yeah. Work within a framework. Information security, again, we have a lot of robust frameworks already to work with. There are some good ones with privacy. They are not nearly as mature or well accepted as security frameworks, but those are out there. And I have notes that go along with this deck that'll point to those. Set your metrics. NIST has a great document that helps with security metrics. There are a lot of privacy things in there as well. Make sure they're quantitative and qualitative, and I've listed some there. You know, recording the number of incidents, recording the average time to respond to. And this is a privacy incident. This is, you know, it doesn't necessarily be a data breach. It could just be somebody complaining that you're misusing their data. And then it goes down. And you know, if a privacy program is something new to you, just, you know, how many plans do you have existing that cover your data, how many employees you've trained, those sorts of things. And so that sort of sets your framework, right? You've got a team appointed, you've got a vision, you have your metrics, you know what you're going to be measuring, you have to measure what you're doing, otherwise how are you going to know that you're successful? And that's not necessarily easy, but then the real work starts. And that first bullet up there looks so innocent. Privacy impact assessment. That's a lot of work, right? So you know, that's inventorying where all your personal data is, who has access to it, how it flows, how you dispose of it, and then matching the risks and, you know, whatever risk model you want to use, but matching the risks to that data is a huge task. But that gives you a scope for what you need to do, and you know, that'll help you review your policies, review your insurance coverage. This is something I keep mentioning, and in every group, a lot of people are like, really? But you know, cyber insurance is awesome. It'll help you pay for a data breach. But so often those insurance coverages cover your computer systems. So if you host your data at somebody else's system, whether it's just a VPS slice, that's not yours. That's somebody else's. So really check your insurance coverage to make sure you're covered. Review your legal obligations. Laws are changing very frequently, so use a legal team to help you with that. And general InfoSec stuff is always good. This is Information Security 101. Right? You've got your policies in place. Enforce them, secure the data, and I've listed this third bullet. Privacy enhanced system design and development was something that's quoted right out of the new NIST privacy controls catalog. And this gets to your point earlier. That is requiring you, if you're responsible for complying with NIST 800-53, to automate your privacy controls. And that, I believe, is ensuring that somebody has to opt in if it's something that is optional. So marketing lists, advertising, uses for third party, the default should be you're opted out. Prepare and sustain, set up your monitoring, have a way of managing complaints. External people will complain that you're violating their privacy. Make sure you have a way of managing that. Create an incident response. This may look different than a security incident response thing. It may extend that. That'll be specific to you, and then train your people. All right, and then the wrapping up would be repeating those things, and I want to make sure I have room for questions. I'm sorry I had to take a little.
We have about 2 minutes to 3 minutes for questions. If anything spills over that time, we do have a speaker area in the back when you first come in to the conference on the right-hand side, so we can continue the discussion.
Absolutely.
But we have a couple of minutes, sure.
And I'm hanging around all day, so yeah.
Does your group play a role at all in working with lobbyists on legislation?
We are a non-advocacy organization, so we do not take a position on any of that. We love the EFF and we love Facebook. Anybody else? So I did that whole auctioneer thing for nothing.
No. To what extent do you think that privacy, trying to advance privacy is complicated by customer misperceptions and confusion?
So this is my personal opinion. I
Yes.
think meaningful transparency is probably the most difficult, but the most important thing we can all work towards together. And by meaningful transparency, it means getting beyond the privacy policy that spells things out and communicating to the user in a way where they understand exactly what they're committing themselves to. Right? And there are a lot of people trying to do this. Facebook takes a lot of grief because they do an awful lot of work trying to be transparent. I mean, their business model is profiling people, so you know they try to be open with that. Google's got a whole good to know site. If you guys haven't seen it, it's a remarkable effort to try to gain some transparency. They've gotten grief for that too. That included consolidating their privacy policies, but that's an incredibly difficult problem. Important.
Just comments or thoughts on general public awareness. You know, my mother-in-law will click any button in the world to play Scrabble online. And
yeah. So that gets into policy, and I can't, as an officer of the IPD, I just can't comment on that. But I will point you to the NCSA, the National Cybersecurity Alliance. They had a Data Privacy Day, and they are making a recent effort to outreach to schools and to the elderly to educate them on privacy.
Yeah. How do you get this paid for within any kind of company or anything? Because it's not at all important to the bottom line until it is.
Well,
And
it's
they don't
a
care.
risk
People
pro-
just don't
it's a
care.
risk proposition.
Yeah.
Right? So I mean, there are very real costs to a data breach, but there are also a lot of costs to brand if things are misused. And you know, we're moving from you could say people vote for their wallet, but in a modern economy, if you're online with free service, people are voting with their data. So that's the proposition.
We probably have time for one more question. Then
You got it.
Yeah, I was going to ask, I guess this is your opinion, why are people so averse to having their information monetized? Why is this such a passionate sort of thing coming up?
It's creepy because it's allowing
Why?
somebody...
What's under that?
Well, I think that's a human nature question. You don't want somebody to know your deepest secrets unless you want them to know it. And this exposes those secrets for others to uncover without your consent.
please remember to fill out your evals, and thank you very much.